Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Sri Vishnu Art Press Publications, exercise number 7 and 8 on the speed of 90 words per minute. Start. Having heard the learned counsel for the parties, we are satisfied that the appeals are liable to be dismissed. It is well settled that one of the co-owners can file a suit for eviction of a tenant in the property generally owned by the co-owners. This principle is based on the doctrine of agency. One co-owner filing a suit for eviction against the tenant does so on his own behalf, in his own right, and as an agent of the other co-owners. The consent of other co-owners is assumed as taken unless it is shown that the other co-owners were not agreeable to eject the tenant and the suit was filed in spite of their disagreement. In the present case, the suit was filed by both the co-owners. One of the co-owners cannot withdraw his consent midway the suit so as to prejudice the other co-owners. The suit once filed, the rights of the parties stand crystallized on the date of the suit, and the entitlement of the co-owners to seek ejectment must be adjudged by reference to the date of institution of the suit, the only exception being when, by virtue of a subsequent event, the entitlement of the body of co-owners to eject the tenant comes to an end by act of parties or by operation of law. In order to cut short further litigation, we are inclined to invoke the jurisdiction vesting in this court under Article 142 of the Constitution. As noted in the earlier part of the judgment, the land standing below the structure has been partitioned. The need for partitioning the superstructure standing over the land was not felt by the landlords as the superstructure was just debris in their assessment, as they had decided to demolish the same and reconstruct the property separately on their respective pieces of land, falling to their respective shares by virtue of partition. In the absence of the superstructure having been actually partitioned, it can be assumed that the superstructure would go with the land and each of the co-owners would, in any case, be entitled to that part of the superstructure which corresponds with the land underneath as fallen to the separate shares of the two. During the pendency of this appeal, we had directed the parties to explore possibility of settlement, if any, and also to draw an agreed map of the property showing the house property divided into two portions indicated in separate colors so as to point out that part of the property to which the heirs of Baldev would be entitled and that part of the property to which Rama Devi, and now her transferees would be entitled. Unfortunately, the parties have not been able to draw an agreed map. Both the parties have filed their separate maps. On a perusal of the two maps, we do not find any substantial difference therein. Sri W. H. Khan, learned senior advocate appearing for the appellant in Special Appeal number 449 of 2011, contended that the order of District Inspector of Schools was liable to be set aside. He submits that there being two rival claimants regarding elections of the Committee of Management dated 31/10/2010, the District Inspector of Schools had no jurisdiction to adjudicate the dispute, and he was obliged to make a reference to the regional level committee in accordance with the government orders dated 1912-2000 and 2010-2008. He further submits that the order of Honorable Single Judge dated 1/12/2010, by which this court directed the District Inspector of Schools to re-examine the matter, cannot confer jurisdiction on the District Inspector of Schools, which was not otherwise available to him, and the District Inspector of Schools ought to have considered the question as to whether he was competent to decide the dispute, or reference to regional level committee was necessary. He submits that the order of District Inspector of Schools dated 11/2011 deserves to be set aside by Honorable Single Judge, and Honorable Single Judge erred in not setting aside the said order. Sri Shashi Nandan, assisted by Sri Arun Kumar Singh, appearing for the respondents, submitted that the District Inspector of Schools had full jurisdiction to decide the dispute. He submits that according to the government order dated 2010-2008, the District Inspector of Schools has been conferred with the jurisdiction to determine the claim of elections of Committee of Management, and the order dated 11/2011 was well within his jurisdiction. He further submits that the writ petitioner did not raise any objection to the jurisdiction of the District Inspector of Schools when the matter was being heard. He further submits that in writ petition filed by the writ petitioner challenging the order of District Inspector of Schools dated 3/11/2010, no ground was taken that District Inspector of Schools had no jurisdiction to determine the dispute. He submits that in view of the directions of this court dated 1/12/2010, the District Inspector of Schools has to determine the dispute, and writ petitioner is not stopped from challenging the jurisdiction of District Inspector of Schools. The submissions of learned counsel for the parties center around to the issue as to whether in the facts of the present case The dispute of rival claims of management could have been decided by the district inspector of schools, or it was necessary for the district inspector of schools to refer the dispute before the regional level committee. Before we proceed to examine the above issue, it is relevant to note the relevant provisions of the UP Intermediate Education Act 1921 as amended from time to time, as well as the government orders issued by the state government. The district inspector of schools under the statutory provisions of the UP Intermediate Education Act 1921 and under the UP High School and Intermediate College Act 1971 had to perform various statutory functions in collaboration with the Committee of Management.